Welcome, everyone. My name is Jessica Roth, and I'm a professor at Cardozo Law School and co-director of the Jacob Byrne Center for Ethics in the Practice of Law. Today, we have the pleasure of presenting a conversation with Carissa Byrne Hessick about her new book, Punishment Without Trial: Why Plea Bargaining is a Bad Deal, which was published earlier this year by the Abrams Press. Carissa is the Anne Shea Ransdell and William Garlick Buck Ransdell Jr. Distinguished Professor of Law at the University of North Carolina Law School, where she also serves as the director of the Prosecutors and Politics Project. Her teaching and research interests are in criminal law, sentencing, and the structure of the criminal justice system. And her work has been published by the Los Angeles Times, the Philadelphia Inquirer, Slate, and numerous academic journals. She also has an informative Twitter account covering criminal justice. Carissa is a good friend to many of us here at Cardozo Law School. She organizes the annual gathering of criminal law faculty from around the country that has become known as CrimFest, and which we have had the pleasure of hosting at Cardozo several times, and hopefully again in person in 2022 at Cardozo. In the meantime, it is a great pleasure to welcome Carissa to Cardozo virtually for a discussion of her excellent and thought-provoking book. If you haven't read it yet, there is a link on the Eventbrite page for this event to the publisher's website where you can purchase it. And we've also put a link in the chat for today's webinar where you can buy a copy of the book and have it delivered in time for the holidays. As Carissa explains in her book, when Americans think of the criminal justice system, they picture a trial. The right to a trial by jury is supposed to undergird our entire criminal justice system, but that bedrock constitutional right has all but disappeared thanks to plea bargaining, which has been blessed and even encouraged by the courts. In 2018, more than 97% of defendants pleaded guilty. Carissa's book, which explains these legal issues in a very accessible way and illustrates systemic problems with real-life stories of people she interviewed. In that book, Carissa makes the case against plea bargaining and argues that we need to fix it if we ever hope to achieve lasting criminal justice reform. So before we begin our conversation with Carissa, I want to let our audience know that we're going to reserve time at the end of our conversation for questions, and you can submit questions in the Q&A function of the webinar. And now I'm going to turn it over to Maura Gingrich, who's the administrator for the Jacob Byrne Center, to discuss some of the logistics about getting CLE credit for today's event. Thank you. Okay, now Carissa, welcome virtually. And what I wanted to start with was asking you why it was important to you that you write this book on this subject for a general audience. It's not an academic book, even though you're a very accomplished academic. It's not even a book geared toward lawyers, I would say. It's very accessible to a non-lawyer lay audience. So why that decision to write it for this audience?
Thank you, Jessica. And thank you so much for inviting me to be here. It's very nice to see you. I look forward to seeing you in person sometime soon. I wanted to write a book for non-lawyers because when I was growing up, I didn't know any lawyers. I'm the only lawyer in my family. I guess now I'm married to another lawyer, so I suppose that makes two of us. But criminal justice and criminal law is something that, even though I didn't grow up around lawyers, I often talked and thought about. And a lot of my family members, strong-willed individuals who talk a lot, all of us, they like to talk to me about criminal justice and criminal justice policy. And it became clear when I was speaking with them and a number of my friends who hadn't gone to law school that they had a different image of the criminal justice system than what exists in reality. And in particular, they think that most cases go to trial, that most criminal laws clearly state what's forbidden, that most criminal laws involve the sort of serious crimes that they might see on television, and that our criminal justice system sort of does its best to get to the truth. And Jessica, I know from your experience, you know that some of those things aren't accurate. I mean, if nothing else, very, very, very few cases go to trial. And I think the fact that our system sends so few cases to trial actually warps and changes the system in important ways that most people don't understand. And so because we ask American citizens to vote in elections for prosecutor or And because they often list crime as something that they care about when they respond to public opinion polls, I thought it was important for people in the public to have an opportunity to learn more about how the system actually works, so that when they have to make those decisions, they can do so in a much more informed way. That, and because I thought my parents might read it.
Well, I'm sure they have. I'm sure they've told you what they think of it if they have. So can you talk a little bit about the history of plea bargaining in the United States, which, as we noted at the outset, is so pervasive now, 97% of cases end in a guilty plea. Was it always that way, or has it been a steady progression, or was there some big jumping off point that got us here?
Yeah, no, it's true that plea bargaining is really pervasive right now, but I think of it as largely a modern phenomenon. That's not entirely accurate, but I'll tell you why I think of it this way. First of all, it's important to know that the history of plea bargaining is very murky. It's murky because plea bargaining, to the extent it occurred largely in secret. If people found out about plea bargaining, they thought it was corruption and people would get in trouble for it. So, for example, George Fisher, in his book about plea bargaining, he went to some Massachusetts courthouses and found some early examples of plea bargaining. Specifically, he talks a lot about some alcohol cases where the Massachusetts legislature had enacted a law that had a set fine for these alcohol violations. And one of the district attorneys there had the bright idea that instead of having to take all of these cases to trial, he'd take someone who had 3 or 4 violations and say, hey, look, plead guilty to one, I'll dismiss the rest, and then I can process more cases. Well, it got out that the prosecutor was doing this, and he actually got called in front of the state legislature and read the Riot Act because he was, according to the elected legislators, depriving the state of the fines that they were supposed to get. And so there are other stories as well about like appellate courts in the pre-Civil War era finding out about plea bargaining, trying to undo it on appeal, saying that it was wrong. And then Will Ortman, who's a professor at another law school, has this really great paper talking about when it was that people really discovered that plea bargaining was pervasive. We know that there have been guilty pleas for a long time, right? But the problem is finding the plea bargain, where it's not just the defendant deciding to plead guilty and sort of let whatever happen happens, but instead reaching an agreement with the prosecutor, negotiating over what the outcome would be, getting something in return for the guilty plea. So Ortman dug into these interesting crime commissions that existed in the 1920s and the 30s, where people were trying to understand the criminal justice system in America's cities. And some of those commissions uncovered rampant plea bargaining. And the reaction was like the reaction I described before. People said it was corruption. They said it was terrible. They interestingly didn't think that defendants' rights were being trampled the way that we currently speak about plea bargaining. Instead, they thought defendants were getting off too easily because the law as written wasn't being enforced to them. And Ortman tells more of a story about how, once it came out into the open that this plea bargaining was happening, it sort of stayed in the public eye in the mid 20th century, started to become normalized. And then it was only in the early 1970s that the issue made its way to the US Supreme Court. And that's when the justices said it was constitutional. But this sort of like open and notorious plea bargaining that we have, the system that we have now, where everyone knows that the cases are being bargained, the judge asks the parties if they've come to an agreement, all of those sorts of things. I'd say it's a modern phenomenon that dates from approximately the mid 20th century.
So it's a very interesting trajectory you trace between it being kind of secret and rare and being scorned upon when it's found, to becoming accepted and then becoming utterly pervasive and the norm, right? Where you write very powerfully in the book about how that sort of cultural aspect of plea bargaining as being the norm and may be doing a lot of the explanatory work now for why it's so pervasive, because everybody just assumes that's what's going to happen most of the time now.
Exactly. And just to add one tiny piece of it, even in the mid 20th century, when it became more open and accepted, we didn't have the rates that we see now, right? It's even in recent years, in recent decades, the number of trials has continued to shrink. So it's been accepted for several decades at this point, but even in the past 2 decades, the number of trials has continued to go down.
So that actually brings us to an interesting point, which is, what are some of the factors that may help explain why the trial rate continues to come down, right? You talk a lot about prosecutors' leverage. But there's so many things that give prosecutors leverage. So can you talk a little bit about that?
Sure. So I think that there are a number of different explanations for why people plea bargain. Some people plea bargain because prosecutors have a hammer that they can hit them with, a metaphorical hammer that they can hit them with if they don't plea bargain. They can re-indict them on more serious charges, maybe charges that carry a mandatory minimum. They can seek restitution that would have dramatic financial consequences. Basically, prosecutors have some very harsh laws that give them leverage to offer defendants a better deal. So that's one piece of it. Another piece of it, though, is even if the prosecutor isn't going to be able to do very much to punish a defendant who decides to go to trial, judges will. So before plea bargaining became quite so open and notorious, judges were known to hand out longer sentences to defendants who decided to go to trial. And it was so common, it has a nickname, right? It's called the trial penalty. So defendants are motivated to plead guilty because they don't want to receive a longer sentence from the judge. And if they're going to plead guilty anyways, they might as well try to get some sort of concessions from the prosecutors in doing that. So that's one dynamic that pushes us towards plea bargains. But I think that there are other dynamics as well. For example, if you look at misdemeanor cases where that same hammer doesn't really exist, and even if the judge is going to punish a defendant for going to trial, because there's such a cap on misdemeanor sentences, there's really not that much more that the judge could do to the defendant. It's not going to be that much worse. In those cases, the dynamic looks different. The system is in no hurry to set cases for trial. And instead, I think maybe because they assume so many cases will plead, defendants are required to come back to the courtroom a dozen times for status conferences where nothing really happens. Sometimes it's just to let the judge know where things are. Sometimes it's to say that the defendant's counsel still hasn't gotten some information from the prosecutor. Sometimes there's a trial tape, but it won't go because the witnesses aren't ready. And this sort of constant bringing people back to the courtroom takes its own toll on them. I mean, they're going to have to miss work. They have to come up with transportation to the courthouse. For a lot of people, these are significant barriers that could really hurt them. And also, if they happen to live in a neighborhood where they're more likely to come into contact with the police, they know that if they have an outstanding charge, another arrest will often mean that they won't be released before trial. They'll be detained, they'll be kept in jail. So they're motivated that way to try to get the case resolved in case they come into contact with law enforcement again. And then I think that there are other very relatable issues, like people don't like uncertainty. It scares them to not know what's going to happen. They don't like to gamble. They'd rather sort of cut their losses or hedge their bets. So I think there are a number of different reasons why we see the very high plea bargaining rates. But I also think that compounding all of this is what you mentioned before, which is I think at this point, everyone just expects most cases to plead. And we're social creatures, humans, like we tend to conform to expectations, not always, but people's expectations of us often drive our behavior a lot more than we probably realize.
So I just want to point out for our audience members, some of whom I hope are not lawyers, that some of the things you talked about that might be shocking to people about the idea of a prosecutor re-indicting with a more serious charge as a way of pressuring somebody to plead guilty, or a judge imposing a harsher sentence after a trial than pursuant to a plea, the trial penalty. These are things that the US Supreme Court has considered the lawfulness of, and blessed, right, explicitly in cases in the 1970s that you talk about in the book. So it's not like the Supreme Court never thought about it, and we might get a blockbuster case next year saying, oh my goodness, we didn't realize that was happening, right? Can't believe there's gambling going on here. But actually, it's been considered and explicitly blessed as being okay.
It has, and I have to say, just because I can't let the opportunity pass, in some really disappointing opinions that say things like, well, plea bargaining, we've already said it's constitutional. And if we said that prosecutors couldn't re-indict on more serious charges, there would be fewer plea bargains. So we should probably allow it. I mean, just terrible sort of ends-driven, like explicitly ends-driven analysis that's really out of step with the Supreme Court's decisions in other areas. I mean, we would never read an opinion by the US Supreme Court where they would say, oh, it's okay for a government official to punish you for exercising a right because it's expensive and inefficient to allow people to exercise that right. And yet that's what they do for plea bargaining.
And the court has explicitly embraced the efficiency rationale, right? And sort of said, if we didn't allow this, essentially the system couldn't function because we have too many criminal cases for everyone to exercise their trial right.
Oh, definitely. I mean, I think the Supreme Court justices, I think, are picking up on the theme from the judges who first adopted the trial penalty, which is the courts have a lot of cases that they need to deal with. They don't have enough resources. So they're going to pressure people into giving up their rights to get these cases off the docket. I mean, the Supreme Court, they took this rationale to heart, even though I think at the time, none of them had been district court judges. But Chief Justice Warren Burger, who wrote the majority opinion in the case that said plea bargaining was constitutional, then went and gave speeches about how important it was to have plea bargaining and that that's the only way that the court system could manage. So he was a deep believer in the idea that trials were bad for the justice system.
That actually picks up on another theme that I found really interesting about your book, which was this sort of distrust of juries as being inexpert that is in the history of the justice system, and an embrace perhaps of plea bargaining for that reason as well. Not just that it's efficient, but actually maybe it's just better to have prosecutors and judges doing this and cut out the juries.
Yeah, there are a few different variations on this argument. I think one variation we saw sort of coincided with the rise of the progressive movement. And I don't mean how that word's used today. I mean sort of the folks that brought us administrative agencies and the administrative state. They pointed out that, much like Congress is this clunky institution that can't get stuff done very quickly, so too are juries, a sort of clunky institution like Congress, not filled with experts, and like Congress that might not have all of the answers that a group of people with more expertise might have. And so this idea of expertise that was creating things like the Treasury Department and the Commerce Department and administrative regulations to help control modern life also suggested that law enforcement and prosecutors should get the same sort of deference, that they spent time investigating these cases. They're in a good position to sort the innocent from the guilty. They're in a good position to figure out what an appropriate sentence would be for a particular crime. And to tell you the truth, juries, I think, are starting to come around to that point of view as well. I mean, the acquittal rates from the 19th century were really high compared to today. Nowadays, a lot of people, if they're brought in on a jury, they do tend to convict at really sort of high rates. And in communities where we don't see conviction rates that are incredibly high, we then get stories, right? So in New York, you guys have the Bronx jury. Bronx jury is still convicted at a pretty high rate. They're just not quite as high as like Staten Island and Queens.
Mm-hmm. You tell the story of someone you call James in the book. All the names of the people you talk about, their names have been changed, but you refer to him as James and how he pled guilty to trespass when he was arrested in the hallway of the building where he lived. He just didn't have identification with him at the time to be able to show to the officer that he lived there. But he nevertheless pled guilty to trespass so that he could essentially just go home and he wouldn't have to miss work. But he was innocent, but he pled guilty. And so we haven't really dug in yet to sort of innocent people pleading guilty. Does your book address that?
It does. It does. And I tried not to focus the book too much on it because it's definitely a problem. It's the, I have a story out of North Carolina that I opened the book with about a gentleman who pleaded guilty to a murder that he didn't commit. There are stories like that. It's hard to know how many stories are like that. A lot of states limit the ability of people who plead guilty to later seek exoneration. Some of them limit access to DNA evidence, and of course, DNA evidence often isn't available. But James's story, the one that you mentioned, I think is sort of all the more disturbing because I think so many of us could relate to it. So James was arrested for trespassing in his own building. He spent the night in jail. And when his lawyer came to speak with him, he explained that he was going to appear before a judge. And at that point, he had two options. He could either plead guilty and pay a fine of, I think, $100 and go home, or he could plead not guilty and he could still go home, but he'd have to come back again with his ID to prove that he actually lived where he lived. And on that date, the prosecutor would probably dismiss the charges, but it's possible it could take one more appearance. And James was just like, no, I'm not going to come back. I'll pay the $100. And he said, because, he'd already had to miss work when he got arrested. He couldn't afford to miss work again. Paying the $100 was economically more efficient for him than missing more work to try to clear his name. And so he pleaded guilty, even though the circumstances sounds like something from a Kafka novel, like being arrested for trespassing in your own home. So when I interviewed James's lawyer for the book, I said, it just occurred to me as he's telling the story. And I said, well, couldn't you just get like a photocopy of James's ID and send it to the prosecutor and they could just dismiss it out of hand? Or you could just show up to court with the photocopy and they could dismiss it then? And the lawyer was like, yeah, that's not how it works. And I was like, but why? Right? When I clerked for a trial court judge, the only time that we saw anyone other than lawyers were in trials and then in criminal cases. In civil cases, the litigants didn't have to come to court unless the case was going to trial that day. They got to stay at their jobs or with their families or whatnot. And it was just the lawyers who would show up for the status conferences. So it just struck me as kind of crazy that we would have different rules when it comes to criminal cases where the people, haven't decided to necessarily be part of the suit or anything like that. But he said when I pressed him about it, he said that he could think of one case and it was possible that there might have been another there were some sort of extenuating circumstances like that would lead the judge to agree to waive the appearance of the defendant at a status conference. And that just struck me as it struck me as such a sort of inconsiderate thing for the system to do, that just because someone's been arrested, suddenly their time is worthless and they're going to get stuck sitting on a bench in a courtroom somewhere waiting for their case to get filed. It's not efficient at all to handle things like that. And yet the plea bargaining system that we have exists for efficiency purposes. Makes me think efficient for some people and maybe we don't care that much about efficiency for others.
You mentioned the fine that James had to pay also, and fines and fees are at least one chapter of the book, but sort of permeate the rest of it as well. What role are those fines and fees that are collected by courts and then sort of sent to different places? What role do you think those are playing in this system as you sort of look at it overall?
Yeah, it's the fines and fees associated with the criminal justice system. I think, first of all, I think there's something that people should know about. So that's a big reason why they're in this book. It's the sort of thing that feels so unfair when you read about it. And I just wanted people to understand how unfair it could feel. There were some fines and fees that I thought just reflected how quickly we are to assume that people who get swept up in the system are guilty and should bear some of the costs of their own prosecution. So like the places that collect an administrative fee on any bail that someone posts. So you might get arrested and then have to post bail so you can go home, pay some sort of financial security to the court. And then even if the prosecutor decides to dismiss the case, the court keeps some of your money as a processing fee to pay for the court itself. It's like, well, that seems terrible. The prosecutor has decided either that you're innocent, or at a minimum, they've decided it's not worth trying to prosecute you. It doesn't seem at all clear why you should have to pay additional money for the inconvenience and, just sort of awful experience of having been arrested. But then it was worse from there. There was a jury trial fee in one state where the sponsor of the bill was very clear that he was imposing it because he wanted people to plead guilty. And it was fine. Everyone accepted it. I think it's been repealed since then. But and other states where even if you're indigent, you get stuck bearing part of the cost of your lawyer. How these fees can add up to be even more than whatever sort of financial punishment you might have to pay. And just how at the end of the day, if we think it's so expensive to bring people into the criminal justice system, one answer would be to bring fewer people into the criminal justice system. But instead, I think what ends up happening is that a lot of states and localities use their criminal justice system as an opportunity to try to make money for other parts of their government. I know here in North Carolina, because of some Supreme Court precedent, judges have to be able to not impose fees on people who are indigent. The Supreme Court case law is bad in lots of respects, but they're pretty clear on this, that somebody who's truly indigent can't be forced to pay a fee. So our legislature responded by saying, okay, well, I guess a judge can waive the fee, but in order to do that, the judge is going to have to send a notification to every department of the states that gets any piece of this fee, and they have to be sent individually for each individual defendant. And it was something like 13 or 14 different departments. And if any of them objected, this judge had to be willing to hold a hearing to hear their concerns about why it was that they needed the fee and that it shouldn't be waived from that defendant. So as you might imagine, the judicial fee waivers have gone down precipitously since our legislature adopted that rule.
So it's pretty clear to see that plea bargaining can put defendants in an impossible bind, right? Or the pressures that they are facing, both from the charges themselves, but also being detained pending trial, or even if they're released, having to come back repeatedly, as you said. I want to pivot a little bit to think about some of the other people involved in this system, starting first with defense lawyers. And then we'll talk about victims and prosecutors and how they are implicated by this. So thinking first about defense lawyers, because you interviewed a lot of public defenders for this book. I mean, doesn't this put them in a terrible position, especially when they have a client like Joseph who says, I'm innocent, but the lawyer talks with them and they can both agree that the rational decision is to plead guilty, even if the client says they're innocent?
Definitely. I mean, the ethics rules require lawyers to let their clients make the decision about whether to plead guilty or to plead not guilty. And so all the lawyer can do in that situation is just try to advise their clients. And I think it's very difficult for James's lawyer to know that he was allowing his client to plead guilty to something that he hadn't done, even though it was James's decision. And I think defense attorneys find themselves in difficult positions quite often, including when they have a client who doesn't want to take a plea bargain and who's really going to face terrible consequences if they go to trial and get convicted. And in those circumstances, I think the defense attorneys, it's difficult for them to know what to do because it's supposed to be the client's decision. And at the same time, it's hard for them to know whether the client fully understands what's happening. So I was talking to one defense attorney, this actually isn't in the book, and he said that when he has a client who really on the facts has a pretty bad case and is insisting that he or she won't take a very favorable deal, he'll have a conversation with them where he says something along the lines of, okay, the trial is set for Wednesday. Do you have someone who's going to feed your dog on Wednesday night if you get remanded into custody? Do you have someone who is going to get your mail? And in putting it in those terms, that as of Wednesday night, the person might be in jail, his clients, most of them, will suddenly say, what was the plea offer again? Let's talk about this some more. Now, of course, for some clients, right, the plea bargain isn't going to get them out of incarceration. They're going to have to go in anyways. But it's those sorts of conversations that defense attorneys have to have with their clients. It's really sort of, I think it puts them in a difficult position because even if they think that their client has a decent chance at acquittal, sometimes the rational choice for their client is still to plead guilty, that the risk might be too great. So I think it puts them in a very difficult position. And then I'll say, I also think that the system more generally, this idea that everything's through negotiation and bargaining can put defense attorneys in a very difficult situation. It isn't my research. There's a book called The Process is the Punishment from someone named Malcolm Feely, where he sat in a Connecticut courtroom for a year watching the interactions between lawyers. And he reports some of the interactions between the lawyers, including a defense attorney saying to a prosecutor, I haven't asked you for any favors today. Can you give this guy a break? Very clear, the lawyers were bargaining across cases. And I understand the need to do that. And at the same time, that seems to be just an absolute violation of sort of bedrock ethical principles about zealously representing, or diligently, sorry, I would say diligently now, not zealously, but diligently representing your client to give up something for one client in return for something for another. It's just incredibly distasteful, even though it might be necessary.
And thinking about victims, I mean, some of the cases you talk about, there are real individual victims of these crimes, but the victims don't always know what the result is of any case or charges brought for the crime that they suffered. So how does plea bargaining sort of impact victims broadly? So
I think that plea bargaining can be very difficult for victims. I mean, victims who aren't lawyers, who don't know much about the criminal justice system, they have no reason to think that anything's going to happen other than the law being enforced and a case going to trial. In fact, I think that the response that a lot of victims have to plea bargaining is similar to the response that I discussed, you know, in the early days when people outside the system found out about plea bargaining, which is it looks corrupt to them. It looks as though the prosecutor is being lenient and doing so because he or she just doesn't want to have to undertake the time and the expense associated with the trial. I think that's difficult for victims to understand. Now, I'm painting with a broad brush here. There are obviously some victims who don't want to have to go to trial. They don't want to have to relive whatever painful experience occurred. And for them, plea bargaining is probably the best outcome where the case can be resolved. They can have some sort of closure without having to see the person who attacked them or wronged them again. But not all victims feel that way. Some victims want their day in court, And because so few people know that plea bargaining is about reducing basically all of the punishments that are on the books, the victims think that the prosecutor isn't punishing the defendant like the law says the defendant is supposed to be punished. Now, people in the system, we know that the laws are written by people who know all about plea bargaining. They know that when they set the penalty, when they set a 5-year mandatory minimum penalty for somebody who does X, most people who do X are going to plead guilty to a lesser crime. And the people who committed the really serious crime that has the mandatory minimum of 10 years or 15 years, they're the ones who are going to be pleading guilty to the 5-year crime. But that's not how politicians talk to their constituents. They say, everybody who does this is bad. We need to keep everyone safe. That's why there's a 5-year mandatory minimum. And so that's the message that most victims have internalized and they think. And so when plea bargaining happens, from their perspective, it's often a failure of the system. Now, maybe they would have been perfectly happy with a 2-year sentence if they'd gone through a trial and the judge sort of said, look, it's a 2-year sentence for this, that, and the other reason. But there's this benchmark out there, and then this process that we don't really see on TV the same way. And so from their perspective, it feels as though the system is letting someone who did something bad to them off the hook. And I think we do them a real disservice. I mean, it's not really in fashion to talk about the criminal justice system being too lenient, but I think that sometimes it can be too lenient, or at a minimum, we should be clear about what we think appropriate punishments are so that it doesn't look as though just pleading guilty is getting you a lesser punishment, because it looks kind of unseemly.
So picking up on some of what you were saying, that victims are deprived of when plea bargaining happens, right? It's not just sort of the ultimate sentence and crime of conviction, but the process of the trial. And as you noted, some victims may not want to participate in a trial, but some may want there to be a public airing of the facts and sort of a public narrative aired about what happened. And it strikes me, and you talk about this so powerfully in the book, that there is this, not to say a cover-up is too strong, right? But this is all done, the plea bargaining tends to be so relatively in private compared to trials that we're losing sort of the airing of those facts. And sometimes the extent to which facts are articulated in court as part of the plea bargaining process and the guilty plea process may not actually correspond to the facts in reality. And you talk about how plea bargaining encourages lying. In fact, it may require it in some instances. So can you talk about that phenomenon, or what it is about plea bargaining that encourages and relies on lying?
Sure. So I think one important thing to keep in mind is that the way the current plea bargaining system works is, in a lot of places, we think that the prosecutor and the defense attorney are supposed to negotiate about the right outcome. An outcome, when it comes to criminal cases, is usually punishment, right? I mean, most everyone's going to get convicted, and the question is, what's their punishment going to look like? And nowadays, with the sort of structured sentencing systems that we have, in order to be able to negotiate about the level of punishment, what the lawyers end up doing is they negotiate about the crime. So someone could commit a crime that carries a relatively high range of punishment and agree to plead guilty to a crime with a less serious range of punishment. And sometimes it might not look that strange to have the person plead guilty to the second crime. So for just to use an easy example, right? You could have the crime of grand theft and then the crime of petty theft, where grand theft is stealing something above $10,000 and petty theft is stealing something worth less than $10,000. If you get someone to plead guilty to petty theft, even though they committed grand theft, it might not look that strange, right? It might be pretty clear what the discount was. Maybe they won't even talk about the value because that's not an element that's being contested between the two parties, like who knows? But that doesn't always work out that way. Like not all criminal codes are divided up with sort of lesser included offenses that fit that neatly. And so instead, what the lawyers have to do is they have to be creative to find some other crime that's not too different, but has the right level of punishment. So for example, there was a custom in Cuyahoga County, Ohio, where in sexual assault cases that were difficult to prove, prosecutors would have defendants plead guilty to a different type of assault. And this type of assault was a particularly sort of low-level assault that required some sort of wrongdoing on the part of the victim to precipitate the assault, right? To like instigate it somehow, to cause it to come about. And I can't imagine that statute, I've read that statute, I can't imagine it was ever written to apply to sexual assault cases. It's obviously outrageously offensive to tell a victim of sexual assault that she caused her assault. There was something that she did to instigate the sexual assault. And it was also being applied in cases where just as a factual matter, it could not be true. There was one case, the woman had been sleeping when she woke up to being assaulted, and yet that defendant was allowed to plead guilty to this particular type of assault. So it's obviously very offensive to victims when this sort of charge bargaining occurs. But then, as you know, Jessica, a plea bargain isn't just something that happens on paper. The defendant has to show up in the courtroom and they have to say what they did. And before they say what they did, they often have to swear an oath that what they're going to say is true. And then they'll proceed to say things that may not be true, even and people in the courtroom know it, right? So maybe in that case, the defendant is saying, this is a case of mistaken identity, I didn't assault anyone. And the prosecutor saying, no, you raped this woman. And they come up with this as the compromise, this low-level assault. Nobody in the courtroom thinks that whatever the defendant is getting ready to say that he did is true. They both think it's something else. So everyone agrees that it's a lie. They might not be able to agree what the truth is, but they agree that this is the lie. And then to compound all of that in Cuyahoga County, as part of the exchange with the judge, so judges have to make sure that guilty pleas, when a defendant decides to plead guilty, they have to make sure that they're knowing and intelligent. They have to make sure that the defendant understands what's happening. And in Cuyahoga County, like in some other places, the judges will make the defendant say under oath that they haven't been promised anything in return for pleading guilty. And that's a lie. Not only do the defense attorney and the prosecutor and the defendant know that it's a lie, but those plea sessions often take place after there's been a meeting in chambers with the judge. And the judge, him or herself, will often say, if you plead guilty, I'm inclined to impose a sentence of X. So the judge has promised the defendant something and then turns around and makes the defendant swear in open court that he or she hasn't been promised anything. So it just, it's really troubling. It makes a liar out of everyone in the system, and it makes a mockery of justice. And there's a young scholar at Rutgers, Taya Johnson. She's just done some excellent work in this area, talking about plea bargaining as lying, the creative plea bargains that are just fiction, right? That sometimes people plead to make, they'll plead guilty to made up crimes that don't even exist in the law books in order to resolve these cases. And her work's really wonderful, and people who want to learn more, I'd suggest that they take a look at her work.
So just picking up on what you were last saying, Carissa, I sometimes had the experience when I was a federal prosecutor in the Southern District of New York of working with a cooperating witness who I would have to put on the stand, and as part of the direct examination, I would bring out all of their prior convictions. And I would sometimes learn in the course of preparing the witness that they had previously pled guilty to crimes that they were telling me they didn't commit. They had done something else, but they took one of these fictional pleas. And so it's very awkward to have somebody explain that they previously lied under oath in that other proceeding because it was part of this plea bargaining process. And that was initially shocking to me when I first discovered it. And pretty soon I discovered it was not so uncommon. But this notion in particular of the judges being involved and there being these sort of off the record conversations about the real facts, then followed by the on the record conversation where sort of the plea is presented. It's very troubling, I think, for many people, and points to among the greatest disservices rendered by the system we've created. But one question I have for you is, among all the things you recount in the book, is there anything that's clearly against the rules of ethics that govern lawyers' behavior? Because there's ethics broadly, which is really, and what we've been talking about, I think, is troubling ethically. But then there's a specific code of rules that govern lawyers, and they can be disciplined for violating those specific rules. And so is there anything that violates those specific rules that you recount in the book?
Yes, there's a couple of stories that I think I'm deeply suspicious of, but there's one where it's entirely clear cut that it was an ethics violation, and I'm just absolutely shocked by it. And it happened in a courthouse in a county in Pennsylvania. There was a journalist that I interviewed. He was like a local court reporter who would travel around the central Pennsylvania counties covering cases. And he was in a courtroom for an arraignment for a high profile case. And as he was sitting in the courtroom, he saw an assistant prosecutor sort of going around and talking to some of the people on the benches, basically giving them plea bargains. So these were probably low-level cases because the people were out and they weren't being detained, and they were showing up for their initial appearance before a judge. And as he explained to me, you could only sort of do two things when similar to in James's case. You could show up and you could plead guilty, or you could show up and you could say not guilty, and you could ask for a lawyer. That was the first opportunity that these people would have to get court-appointed counsel. And so he's sitting next to this woman, or near this woman. The prosecutor comes over, hands her a file, and gives some sort of offer to the ADA, who's also a woman, gave a plea bargain offer to this woman who was sitting on the bench. And the woman looked at the file and said, well, I think I want to ask the judge for a lawyer. And the prosecutor responded to that by taking the file out of the woman's hands. And the woman apparently reacted sort of startled, and she said, well, if I ask for the lawyer, does that mean that I can't have a plea bargain? And the prosecutor said something along the lines of, well, you can't have that plea bargain. Maybe we can get you another one, but that one's going to go away. And as you know, Jessica, prosecutors, like other lawyers, have rules that they need to follow when dealing with people who are not represented by counsel. Actually, they have to deal with probably even stricter rules when they're talking to people who are represented by counsel. But when people aren't represented by counsel, there are rules about how you can talk to them and what you can say. And prosecutors have a special rule where they're not supposed to try to get uncounseled defendants, so defendants who don't have lawyers, to waive important pretrial rights. And frankly, the right to an attorney is a really, really important pretrial right. And this woman wanted an attorney, by the way, an attorney who could help her understand her case, who could help her understand her options, and who could then also be in a position to bargain with the prosecutor. And the prosecutor just thought it was outrageous that this woman was going to insist on her right to counsel, and thought that she should be punished by having this plea bargain taken away from her. Now, the thing that's crazy about that story is that I can totally understand why the prosecutor did that. Prosecutors routinely tell people that if they exercise any rights, that their plea bargain will go away, right? Or they'll even give them exploding plea offers. Like, here you go, here's your plea bargain, it expires in 3 days, let us know. So if you have a lawyer, there's actually no problem with the prosecutor telling the lawyer, if you want to see discovery, this plea bargain is going to go away. If you want to file a suppression motion or ask for a preliminary hearing, this offer is going to go away. And the courts say this is totally fine. They say, look, it's a contract, and you can get a better deal by waiving more rights, so that's okay. But the professional rules tell us that things have to be different if somebody doesn't have a lawyer. So even though it fits this pattern of this sort of high stakes plea bargaining and the insistence that other rights get bundled into the plea bargain along with the right to a jury trial, it's also deeply troubling. I think this prosecutor didn't give it a second thought that there was an ethical obligation about dealing with uncounseled people, because the idea of pressuring people into waiving their pretrial rights is just part and parcel of plea bargaining.
And what's striking about that story also is sort of how open and notorious it was, right? That there was no concern about somebody overhearing it, as you said.
No, not at all. It was done in plain view of dozens of other people in the courtroom, including a reporter for the local paper.
Yeah. I want to think about it from the prosecutor's perspective, though, which you were sort of generous in trying to put yourself in that prosecutor's shoes a moment ago. I mean, are there ways sort of that are broader in which prosecutors are put in a difficult position by the system that's been created sort of around them?
Well, so I feel like I should be turning the tables to ask you, but I'll say this. I think that asking prosecutors to represent the state asks them to take on a lot of responsibility, because unlike other lawyers, they don't have a client that's telling them what to do. So I think that prosecutors need to use a lot of their own personal judgment about making decisions in the course of a case. So I think that already places a lot of responsibility on them. Layered on top of that is another sort of set of responsibilities, which is that we all know that we've written our laws in a way that's too broad, that aren't they can't take all of the circumstances into account. And we rely on prosecutors to use judgment in making decisions like that. So I'll give you another North Carolina example. So here in North Carolina, we had a really strict law against gambling. There were no exceptions. You just couldn't gamble for money or things of value. And so a local prosecutor brought charges against a group of guys at a retirement home, and against a group of senior citizens who were playing nickel and dime poker. He brought these gambling charges against them, and the local paper got a hold of it, and they're like, "You idiot." And the reporter who was writing the story, to his credit, called up the chair of our legislature's, I think it was the Senate Judiciary Committee, said what happened, and then said, is the legislature going to change the law to exempt this sort of gambling? And the chair of the committee said, no, but in the future, we hope that prosecutors will use better judgment. And I think that it's a terrible story, but it shows that legislatures rely on prosecutors to say, look, I understand the statute is written this way, but I'm not going to enforce it in this circumstance because that doesn't seem to really get at the problem that the legislature was trying to solve. So you have to make all the decisions because you don't have a client telling you what to do. Then there's the legislature is asking you to use your judgment to not do injustice in particular cases, right? The Robert Jackson speech to the federal prosecutors, where he says that they have to try to do justice and not just win their cases. I think that's already a lot of responsibility for prosecutors. Plea bargaining, I think, adds too much, because it doesn't just ask prosecutors to bring criminal charges and then to use their personal judgment when doing that. It also asks them to be the judge and the jury. It asks them to be the jury because it's asking them to find the facts. It's telling them that they're supposed to decide who's guilty and who's innocent, not just if there's probable cause to support the charges and then it'll go to trial, it's not going to go to trial. They have to make the decisions. So they're supposed to be making the decisions about whether they think there's proof beyond a reasonable doubt. And then they have to be the judge because they have to figure out what the right sentence is supposed to be. And then they negotiate for that with the defense attorney. It's easy to do the sort of 10th grade civics class version of why this is bad, right? We've got a separation of powers problem where we're asking prosecutors to do both the job of the executive branch and the job of the judicial branch. We can do a sort of like populist, like we want the jury in there because they're the circuit breaker of democracy. But I think I would just go with, that's asking too much of one person. It's asking them to wear different hats. And I don't think that very many of us would be good at that. I think I would be bad at it. And I think pretty highly of myself, and I still think that I would be pretty bad at it. And so I think it's easy for us to criticize prosecutors for how they use the power that they're given. But I have to say, I think it's really unfair that we've asked them to exercise all of that power in the first place.
So is the logical conclusion of your argument that we really should not allow plea bargaining? Prosecutors should charge the crime they think is appropriate, exercising their discretion, and a defendant can plead guilty and the judge can impose whatever sentence within the law that the judge thinks is appropriate, but there can't be bargaining between the prosecutor with respect to either charges or facts relevant to sentencing.
Yeah, I mean, look, Jessica, if I were designing the system from scratch, I'd say yes. I'd say we'd set the sentences at what people should get, what everyone should get, no matter whether they plead guilty or they go to trial. If people really want to plead guilty, that's fine. Let them choose that, but they should be treated the same. No bargaining. You bring charges, it has to go to the jury, unless you discover there's a problem with your case, in which case you dismiss. But that's not the system that we have. We have very harsh laws, some of which have been written in order to help facilitate plea bargaining. We don't have enough courtrooms for that to happen all of the time. And I think, and then layered on top of that, we just have a culture of plea bargaining that you can't stamp out by just telling people not to do it. In fact, we have some examples from the late 20th century where a few different places tried this. They tried it in El Paso, they tried it in Alaska. I think they might have tried it someplace in Arizona as well. And everyone still plea bargained, right? They just did it in secret and didn't tell their supervisors because they were so used to it and because the laws were written in a way that really helped them plea bargain. So I don't think that we can stamp out plea bargaining. And frankly, I think what we need to do is we need to make plea bargaining more fair and maybe unsettle the expectations that everything should be a plea bargain rather than a trial.
And so how do we do that? I mean, I am thankful that you don't end on a pessimistic note in the book, right? Your conclusion points to some areas of progress that you see coming from different institutional actors. So can you talk a little bit about sort of where you do see glimmers of hope?
Sure. So to get back to the story of James, who was arrested for trespassing, which I just think is just such a terrible story, that I told it on a panel before the book came out, like months and months ago. I was asked to serve as a commenter on a panel for Judge Rakoff's book. And at the end of the panel, people were like, what change would you make to the criminal justice system to fix plea bargaining? And I was like, I wouldn't make people come to their pre-status conferences. And I remember the moderators being sort of like, okay, thank you. And a day or two later, I got a phone call in my office, and it was a newly appointed judge in Ohio who had been on the state court before being appointed by President Trump. And he said, oh yeah, he's like, I did that. He was like, it only took me a month to be like, wait, why are the defendants in all the criminal cases being forced to come to my courtroom? We don't need them. This is just a status conference. So he just put a standing order saying, unless it's a change of plea or a trial or the sentencing, defendants don't have to come to court unless I direct their lawyers otherwise. And he said people were shocked. And then he said, and there was absolutely no problem with it as soon as he issued the order. That's just what started happening. I think in misdemeanor cases, and I know it's not really sexy to talk about misdemeanor cases. Everybody cares about felonies and serious crimes. But like, there's like 13 million misdemeanor cases a year as compared to like, is it 1 million or 1.5 million felonies? Like, if you could do something to fix plea bargaining in misdemeanor cases, you would have fixed an awful lot of the system. So I think that sort of constant grind of being forced to come back to the courthouse, just changing that for defendants, at a minimum, it would allow them to negotiate an outcome to their case that they think is a good outcome. And it's not like, I can't get off work next week and so I better plead guilty.
So on that, do you think sort of the Zoom revolution that we take away from the COVID pandemic offers anything? I mean, our courts have been doing a lot of status conferences now online. Does that offer any hope?
I don't know. That's a good question. I think it really depends on where you are. I think in a lot of places, they sort of stopped doing things. And it was funny. I talked to a prosecutor in a county where nothing was happening in any cases. And I said, well, why is nothing happening in any cases? Can't you do things on Zoom? And he said, well, the judges have been adamant that we can't have trials on Zoom. And I was like, okay, well, that makes sense. But nothing goes to trial. So why is everything at a standstill? And he said, oh, yeah. He's like, the trial date is what causes us to move forward in cases. So there are no trial dates, so nothing's happening. So I thought that was really interesting, right? That even though everyone knew that the cases wouldn't go to trial, since a trial date hadn't been set, there was no forward momentum in the cases. I just thought that was, I don't know, I'm not sure what to take away from that. But so I think it would depend, right, how comfortable people are with it. And then also, too, whether the defendants are able to get on Zoom. I suspect that, some of the stories that we've heard about virtual schooling, especially in poorer neighborhoods, make me worried that there are a lot of people, the ones who probably are the least able to show up for the status conferences would also have real problems getting on Zoom for a status conference as well.
And so what are some other than, sort of getting rid of the requirement that the defendant be present? Are there other practices or types of courts? You write about some sort of justice courts and some other sort of new experiments that may offer some promise?
Yeah, so justice courts, different states have different versions of justice courts. The one that I visited that I thought was promising was out in Utah, where basically they didn't want to have to set up sort of formal courts. So they have these informal courts where you can have a trial in front of someone who's not really a judge. They have a judicial appointment, but they're not a judge.
We have that in New York, and they're actually called courts.
Oh, okay. Well, there's called justice court. It's called justice court. They call it. And if you lose, if you win in justice court, you go home. If you lose in justice court, you get a complete do-over in the district court, which is a formal court that can handle. So they only do sort of low-level misdemeanors in the justice court. And there are problems with them. There are reasons that the public defenders there in Salt Lake that I talked to were skeptical of them. But at the same time, they said that their practice in justice court was very different from their practice in the district court. Because in justice court, if they had a case that they thought was a loser, but the client wanted to go to trial, they were like, okay, sure, let's go. And in addition to that, if they thought that the case was weak, they could just tell the prosecutor, by the way, blah, blah, blah is a weak part of your case. And the prosecutor, instead of coming at them with a good plea offer, would be like, all right, and dismiss. Because they knew that the good plea offer was probably going to get turned down because they'd get a second bite at the apple. So it just changed the dynamic in a very interesting way. Not that there were that many trials, there were still only a small percentage of trials, a larger percentage than there were for felony trials and in the district court, but a much higher rate of dismissal, which suggested to me that the prosecutors were really uninterested in holding trials.
I wonder also if there was something about the novelty of the institution that encouraged that openness and sort of a shift in culture, that if you were practicing in this new court, sort of your expectations about what was supposed to happen could be let go of more easily.
I think that's right. And it was interesting because the public defenders I talked to, they would cycle through. They would spend some time in felony court. They'd spend some time in district court. They'd spend some time in justice court. And they were like, oh yeah, justice court is totally different. It had its own different culture. And I think that really mattered.
Yeah. And let's talk briefly about the progressive prosecutors, using progressive in the current sense, who have in some instances stated quite publicly that they will not prosecute certain categories of low-level offenses. Do you think that's an appropriate exercise of their discretion to sort of in this categorical as opposed to case-by-case manner? And is that a response that's worth embracing sort of in the face of sort of otherwise crushing caseloads and what you have described as one of the factors that contributes to sort of the hydraulic force of plea bargaining?
Yeah, no, that's an excellent question. I'm very excited to talk about it. Because I think the answer here is, I'm going to talk about a very obscure law review article, and I promise it will make sense. But so here's, I think, the important thing to understand about what the progressive prosecutors are doing with their non-enforcement policies. I think a lot of what they're doing is just being open about what was happening in that office before they came in. So if you look at Boston, for example, where Rachel Rollins' non-enforcement policy probably has gotten more attention than any of the other prosecutors. She said, for example, she wasn't going to prosecute cases involving thefts of amounts of less than $200. I've seen some numbers somewhere. Basically, her predecessor was also not prosecuting these cases, or if he was prosecuting them, it was a handful of cases, almost nothing. The police would refer the cases to them and they would not bring charges because they didn't have the resources to do it, or because they didn't think that they were quite serious enough. They never really said, they just didn't do it, and they didn't tell anyone about it. Now, I think that the fact that America elects its local prosecutors is both a blessing and a curse, but the idea that people within the community can decide what their priorities are for which crimes should receive more resources is an upside to having elected prosecutors. Rollins announced her policy and she was elected by her community. I think it's better for her community to know what her priorities are so that if they disagree, they can tell her or they can vote her out, than for offices to do these things behind closed doors. And I have no doubt in my mind that all offices have enforcement policies, whether they are formal or informal. It's very clear. They're often called enforcement criteria. Whatever they are, you hear people talk about it. I've had a number of prosecutors speak with my students over the years where they talk about non-enforcement policies. Jim Comey famously talked about the non-enforcement policy when explaining why he said no reasonable prosecutor would bring those charges against Hillary Clinton. He revealed DOJ's enforcement policy for that particular statute. The problem is we almost never know what the enforcement policies are, and I think that's a democratic problem. But I promised you an obscure law review article. This obscure law review article, it's called like acoustic separation, which I still don't know what that is supposed to mean. But the idea is basically this. You can have a good policy, but if you tell people about your policies, people knowing things can have other consequences. For example, if you have a policy that you're not going to bring criminal charges against somebody who steals less than $200, people now know that if they steal less than $200, they won't get convicted of a crime. And I don't have to explain why that might be a problem because everybody's already seeing the headlines across the country where progressive prosecutors are being blamed for the uptick of crime in their communities because of their different approach to when charges are appropriate. Now, there's a big response to be had there about whether they're not enforcing the crimes that are supposed to be going up. There's good reason to think that that's not true. There's a bunch of fighting over sort of what's going up, what's being reported, all of those sorts of things. Ooh, the Obscurity article just got posted in the chat. Thank you, Maura.
Thank you, Maura. Oh my goodness.
But I don't think that it gets past the sort of visceral reaction that people have, that if they hear there are no consequences, they assume that other people will do bad things, even if they're not doing bad things, and they think it will lead to lawlessness. So it leaves me sort of torn about the progressive prosecutors, because on the one hand, I really admire the idea of transparency and the transparency itself. Even if I might disagree with some of the specific policies that these prosecutors have adopted, I admire them for telling their community what their policies are. At the same time, it's hard not to see a backlash against some of these people, by people within their community, and then some people outside of their community. I mean, Bill Barr didn't pass up any opportunity to criticize the progressive prosecutors, sometimes by name and sometimes not by name, and to blame them for the problems that were happening. I don't know what's going to end up happening to the people in these offices. I mean, I think at this point, it's pretty clear that we've had a pretty significant uptick in shootings and homicides in the country. Something needs to be done about that. No, let's be clear. I don't think that any of the progressive prosecutors are failing to prosecute shootings or homicides. We can't, I think, draw a straight line between any of their policies and the increased crime that we've seen. But I will say that I'd be surprised if we don't see if we don't see some sort of reaction to this playing out in elections going forward.
And to what extent would you want to really push people to push their politicians and legislators to change the substantive criminal law and the sentences, to really either get rid of or reduce mandatory minimum sentences, some of these things that are also driving plea bargaining by putting those sort of big hammers in prosecutors' hands? Should that be a big part of the push for reform, do you think?
So I think that real reform, like genuine reform that changes the system that we have now, has to include that. I think it's probably the most difficult reform to bring about. I've been doing some research on criminal law legislation in the states and what legislatures do. And even in recent years, as there's been more attention being paid to mass incarceration, state legislatures are still very eager to create new crimes and lengthen sentences, and very hesitant to create new defenses or criminalize or shorten sentences. So the politics there still seem to be pushing the criminal codes to get sort of bigger and harsher. And I think only if those politicians get a very clear message from their constituents that they want some sort of change is that likely to happen. I think that the more people understand, the more voters who understand that mandatory minimums are just a bargaining chip in plea bargaining, they're not what is actually going to happen in most cases, the more people might be willing to let go of mandatory minimums as a good way to respond to crime. But I think it's going to take a lot of education of people in the public and a lot of soul searching for people. Do they really think that someone who commits, an armed robbery needs to go to jail for 35 years? 35 years is a very, very, very long time. 5 years is also a long time. If you gave someone 5 years in prison, that still changes their life dramatically. But somehow in America, we've convinced ourselves that we need to give out sentences almost of biblical proportions in order to show that we think what someone did was wrong.
I was struck in the book, you talk about how people don't know what the authorized sentences are for many crimes. If you do a public opinion poll, if people think the criminal laws are harsh enough, many people will say, no, they're not harsh enough. But then you ask them, well, what do you think the authorized sentence is for a crime? And the answer they give is actually lower than what actually is the authorized sentence. So I thought that was fascinating and really goes to your point about the need for more public education, which your book is a part of.
Hopefully, yeah, it's we seem to get sort of constant confirmation that people don't really understand what's happening with crime in their communities and elsewhere. People think crime is going up when it's actually going down. People think that judges are free to give suspended sentences to anyone who walks into their courtroom. I think a certain amount of this is the way crime gets reported on. And there's some good literature out there on that too. So I think it's informing the public. I think it might also be working with journalists to maybe talk to them about a different way to cover crime that still seems like important stuff that folks should read, but maybe doesn't lead to the same bad effects that we've seen when it comes to legislation.
So we had one question in the chat about the difference in plea bargaining that people with resources that they experience from people who do not. Now, plea bargaining goes on across the board in all kinds of cases, and defendants who have resources and those who don't. Did you find any notable differences in those experiences?
Yes, no, I mean, there's definitely a difference because the cases are resolved through bargaining. And so how long your lawyer can spend on a case matters a lot. If your lawyer has 200 other cases just like yours, they're not going to have enough time to investigate your case and figure out what the weaknesses are. And they're also not going to necessarily have enough time to just sit down with the prosecutor and make them listen. There are sadly high profile examples of people whose where their lawyer seems to have gotten them something that no one else would get. The Jeffrey Epstein case comes immediately to mind, where his lawyers were able to get, I'd go with an unconscionably lenient plea deal from the US Attorney's Office, which agreed not to even bring any federal charges for someone who'd committed just terrible acts of abuse, in part because it was clear that he had great lawyers who were going to fight incredibly hard and make their lives miserable. But that said, the leverage that I've been talking about, a lot of it exists when it comes to white collar defendants as well. I tell the story in a book about a man who was accused of fraud and who was facing up to 200 years in prison, and who hired himself a very good lawyer and ended up getting a better plea deal out of it. He thought he was going to go to trial and get acquitted, but he eventually ended up pleading guilty because the prosecutors just had so much leverage. The way the federal laws are written, it's actually very harsh for people who are accused of white collar crime. So does more money and sort of fancier lawyers get you a better outcome when it comes to plea bargaining? I'm sure it does. His outcome would have been significantly worse if he hadn't had that money and that very talented lawyer. But it doesn't mean that the system doesn't still sort of get convictions where maybe it shouldn't. It's hard to know.
Well, we've been addressing some of the questions as we've been going through our conversation. Carissa, thank you so much for joining us to talk about this book. Wait, we have one more question that just came in, and we have the last question we'll address before we go. Are there ways that you can share briefly as how we can reform the damage caused by rampant plea bargaining, regardless of who's essentially responsible? Sort of what are things we can do going forward?
Yeah, so I mean, I mentioned just trying to get judges to change the rules in their courtroom about making misdemeanor or really any defendants come to court. Supporting things like bail reform, where people who are accused of crime, where the presumption is that they would be released rather than staying in jail before trial. There's some high quality research that's been done by folks at the University of Pennsylvania showing that people who are detained before trial are far more likely to plead guilty and to get worse deals because they're just not in a position to really help themselves, and they're sort of desperate to get their case over with because they're being kept away from their loved ones. Those two things, trying to change the substantive law so that it really gets at the things we care about and isn't so broadly written, trying to bring down the penalties associated with it. But then I also think it's frankly inexcusable that we have judges who feel comfortable imposing trial penalties on defendants. And I was happy to see a couple of days ago that Senator, I think it was Senator Whitehead, asked a bunch of current nominees during their confirmation hearing about how important juries are and whether they would sort of stick up for juries. They all said yes, it was very specific. Nobody mentioned plea bargaining or the trial penalty, but those sorts of questions, if he'd asked about the trial penalty and asked them whether they're committed to treating people who insist on their right to trial no differently than people who decide to plead guilty, I think that public pressure in this space could actually do quite a lot. Individual judges have a lot of power and they tend not to exercise it in this area, or when they do exercise it, they tend to exercise it in a way that sort of reinforces what I think are really sort of pernicious aspects of the plea bargaining system. So that could change things as well. And then finally, if you have a prosecutor election coming up where you live, we have one here in the county where I live for the first time in decades. We're going to have a contested prosecutor election. We're going to have a candidate forum here at the university where students will get to ask questions. I imagine one of my students will ask a question about plea bargaining. You should ask those questions. How can they be certain about the cases that they're going to insist that people plead guilty to? Will they agree to not re-indict on more serious charges just because somebody insists upon their right to trial? I think a problem here is that most people don't know what's going on. And so a lot of this is hidden from view. And I think more people who ask questions about it might make the people who are in a position to make important decisions a little bit more careful about the decisions that they make.
All right. Well, again, Carissa, thank you so much for joining us. Thank you, everyone, for joining us at home. And again, in the chat is a link to where you can buy a copy of Carissa's book. Thank you, Carissa. Good night, everyone, and happy holidays.